Hello, my dear friends. We welcome you to another session of Voice of Legal Immigrants on Mana TV and Mana TV International. As promised to you, our motto is to keep you updated about the current legal immigration trends in the United States of America. Having said that, we have to bring a good guest to the studio to educate you and make you aware about the current trends. Doing that, we have our esteemed guest today, Mr. Bhanu Illandra. He is an attorney and he is based out of Virginia in Washington DC suburbs. He has his immigration law firm there. A person who has been educating a lot of legal immigrants in the USA about safeguarding their rights as well. In fact, today happens to be a very special session, a discussion. The topic that we are having is about the USCIS and the current scenario that affects the H1, F1 and H4 visa holders in the United States of America. We will have a healthy discussion today and we would definitely like to hear from you. If you have any questions, please do call us live at the Mana TV studios. Well, now we take it on from here. Welcome, Attorney Bhanu. Welcome to the show.
Thank you very much. Thank you very much for inviting me for today's show.
It's a great pleasure to have you here. And of course, there is always a need for the people to get educated, to be aware of what is happening around. And especially to the legal immigrants, we have to focus on a lot of things. And that was the thing, I know we have three diverse topics to discuss. In fact, in legal immigration, three different categories ranging from H1, F1 and H4 visa holders. We can talk a lot about that. So it's been time when I thought I should bring in somebody who can really, enlighten us. But before we do that, Bhanu, definitely our audience are curious to know about you. Tell us something about your background.
Ms. Jyotsna, my name is Bhanu Illandra, as you know that. I'm an immigration attorney. I've been practicing immigration law for almost 15 years now, from 2004 onwards. We started our own law firm in 2008. So it's for more than 11 years now I have my own law firm. I exclusively practice in immigration law, basically. I do all types of matters in immigration law, just not only H1Bs, green cards, H1Bs and H4s or F1s, anything like that. I do all types of matters. EB-5, family-based petitions, even sometimes. I did few asylum cases and refugee cases also in my life. I did few remote proceeding cases also. So I do all extensive immigration practice in our office, basically. Our office is located in Herndon, Virginia. And we are starting a new office also in Piscataway, New Jersey.
Oh, that's great.
And that's where we are in from. And thank you very much for inviting me to the show.
So, no, it is great. I mean, of course, it is good to expand and, provide your services all over.
Yeah.
And do you take questions online as well from people and you give them guidance on the phone,
Yes, we do have
advice on phones also?
Yes, we do have phone appointments and everything, so people do call us on telephones and then we advise them, basically.
So basically you have a pan-US presence irrespective where you're based out of?
Exactly. I'm eligible to practice immigration law in all 50 states in the country.
Oh, amazing.
So we have clients all across the country, basically.
Okay, you're not restricted to any state,
No, in immigration law we are not restricted to any particular state.
That's excellent. I was never aware of that, in fact.
Yeah.
It's good to know. Most of the people also get confused. Okay, you're based out of a particular area, probably that's the only area, you will be giving your, services to. Okay, so for an immigration attorney, an immigration attorney can practice all over US?
All over the US, because immigration law is a federal subject, so they are basically governed by supremacy clause. They practice, basically, therefore, they're eligible to practice immigration law in all 50 states. The only requirement is that they have to be licensed at least in one state in the US, basically, and in that way I'm licensed in New York.
Nice.
And practice exclusively immigration law, so that's why we established our office in Herndon, Virginia.
Okay, perfect. So Bhanu, of course, I want to start from the students category, the F1 visa, regarding the OPT and CPT. There was some issues, there were a lot of news, that was happening. There was a lot of controversy behind, some litigation also happened. Throw some light about the F1 students in USA, what has happened in the past. Throw that light on the, tell to the audience here, and what has happened and what's happening, everything.
It's actually, there is some positive light about the F1, about the students in this country, whether they're F1, M or J visas basically. See, the USCIS issued unlawful presence memo for the students that came into effect from August 2018, right? Basically.
So August 2018, the USCIS issued
unlawful presence memo.
Presence memo
For the students basically. That basically, that memo is created a lot of adverse impact on the students.
Can you explain that memo? What was the
sure. The memo says that
meaning about what is the meaning of that memo?
Sure. The memo basically it tells you that if the students are basically violated their status in any way, deemed to be violation of their status, they start accruing unlawful presence from the day one that violation occurs basically.
Okay.
Okay. Or from the August 9, 2018, that is the day the memo came into effect, from that day they start accruing unlawful presence. The reason why it is so important is in the past, F1 students don't accrue unlawful presence if they found that they're in violation of status. It has to be determined by the USCIS or by the immigration judge that they are in violation of their status, and from that day, the determination has been made, they start accruing unlawful presence. Violation of status, being out of status and being unlawfully present are two different things basically. If you're out of status, you may still be able to go abroad, get visa stamped and then come back, giving you valid reasons why you overstayed in the US. But if you're unlawfully present, then there are bars coming into kick in basically. The bar is basically that prohibits you to entering to the US for a certain period of time, okay? If you're unlawfully present more than 180 days, then you have and if you leave the country after 180 days, then you have a 3-year bar to enter into the US.
Oh.
And if you stay more than 365 days, then it's going to be 10-year bar. So to identify the difference between unlawful presence and the out of status. So this has caused a lot of problem basically because there are a lot of students who basically because of the H1b cap issue, although they have an employment, they could not get H1Bs, and basically they wanted to study at the same time they want to continue working for the employer because it gives them on-the-job training basically for them.
Absolutely.
So under those circumstances, basically a lot of students have joined second master's degree on some other program which allows them to obtain practical training that gives them on-the-job training because they believe that, I think a lot of students believe that on-the-job training is more important for them.
Basically that is the OPT that they do.
CPT and OPT
CPT
basically.
and OPT.
Both of them are practical trainings, which is very, very important for them because that gives them the real-time practical experience. They get exposed to real world basically. What happened is when this memo has come, automatically a lot of students start accruing unlawful presence from August 1. They have too much adverse impact on them, basically their status, their issues and everything.
Right.
So what happened is many colleges and universities, they came together and they filed a lawsuit against them. In 5th Circuit, I believe. I don't remember exactly which circuit it is, but they filed a lawsuit. And
so the universities filed a lawsuit against the
USCIS.
Okay.
And then the judge basically gave a temporary restraining order. It's not a permanent restraining order, but it's a temporary.
So what is the meaning of a temporary restraining order? So
let me explain. Sure. I'm going there basically.
Yeah, okay.
The judge basically issued a temporary restraining order and halted the implementation of this unlawful presence memo.
Okay.
So restraining order means it basically prohibits the government to implement certain policy basically. So it's a temporary restraining order. That's not a permanent restraining order. Right. Judge hasn't made a decision on that case yet. But judge said that, but the university stated that until the judge makes a decision, it's going to cause severe harm to the students.
Right.
Therefore, they need a temporary restraining order implementation of this policy. Because the judge issued this temporary restraining order, now this USCIS unlawful presence memo policy will be kept on hold right now. So that's a good news for the students because if the students are CPT program, for example, if they're doing CPT in second master's degree or if they're taking day one CPT, by default they don't start accruing unlawful presence.
Right.
You know, in the past they used to accrue. We basically warned every student or quite a few times they need to stop at taking CPTs and all these things. Now the case is in the court right now. Until that case is done, DHS cannot implement that policy. So if any students are determined out of status also, he does not have an unlawful presence accrual, so there will be no bars will be applicable to them. So they should be able to go abroad, again apply for a visa and then come back to this country to come into valid status. So that is what is happening to the F1. That means now the status quo is same as it was there before August 9, 2019 for all these F1 students. And we have to see how the judgment goes. It's a very important case which is going in the court right now, which determines F students. Like there are many cases going in the USCIS, as you know right now, about H1Bs and everything also. So I think this current administration.
So when do you expect the judgment to come on this? Any tentative dates?
To be honest with you, no, I don't know because I have not privy to this case.
Okay.
My knowledge is only about reading the news on this case, basically.
Right.
But I think it may take 2 months, 3 months,
Okay.
or maybe even more. We do not know that.
I think I have a caller. Hello. Can you please tell me your name?
Yes, hi. My name is Raj.
Hi Raj, how are you?
I'm doing good, thank you.
Okay Raj, any questions to Bhanu? Please put that.
Yeah, sure. My question is related to H1b visas and the immigration related to it. Recently, we've been hearing of a lot of H1b extension denials and the petitions getting denied. I just wanted to know more about the worst case scenario in that case.
Okay.
I just wanted to know if a person, if his I-94 is expired and he's waiting for his extension to get renewed, and if in case, God forbid, it gets denied, what would be his situation? How much time would he have living in the country? And what are his options of staying in the country? Can he file a transfer during that time? Or, I just wanted to know how he can stay in that case.
Raj, I got your question, Raj. Unfortunately, if your I-94 gets expired and if your H1b extension gets denied, you do not have many options available for you. Basically, from the day it's get denied, you are considered out of status and starts occurring unlawful presence. You basically have, usually although it's not written anywhere in the regulation statutes, usually USCIS understands that you may have 10 days grace period to leave the country. Basically, they usually say that 10 days is okay to stay in this country, and after that you have to leave the country. And unfortunately, if your I-94 expires, you have a very few options to do after the denial of extension, like for example, to file change of status to any other status or to file one more H1b petition. These all basically are limited for the individuals whose I-94 is expired and if their H1b gets denied. Only option is basically is that if you think that H1b is denied erroneously, yes, you can file an appeal to it or you can file a litigation in the court. There are various options available for you to see what kind of remedies are available based upon the case and everything. And also try to see if you can file a non-proton H1b petition if it's an erroneous denial by the USCIS. Those are the two options probably available. However, those two options does not bring you back into legal status and will not stop you accruing unlawful presence in this country. So it is what it is. Unfortunately, very few options are available for the people if their status gets denied, if their extension gets denied, and if their I-94 gets expired.
Thank you so much, Bhanu. In fact, thank you, Raj, for the question. Of course, we have a whole series of questions there lined up for H1 category. Of course, I had kept it for the later part of the discussion because I know this discussion would be a longer one.
Yeah.
So, in fact, of course, I'll come back to H1, but then before that, of course, I wanted to discuss about the H4, also about the recent introduction of the biometrics for the H4 visa holders. Can you explain everything in detail about, I mean, there's a little confusion about it, and then will this biometrics lead to delays in your H4 extensions and, you know, everything?
The USCIS recently introduced regulations. Basically, they started requiring all the I-539 applicants, except few categories. Basically, whoever is an I-539 applicant, they're supposed to do the biometrics also.
Excuse me, but what is I-539 applicants?
I-539 is basically seeking a change of status or extension of status in this country for other than employment-based petitions. For example, if you're a H1b dependent, if you're an H4, you have to file I-539 application. If you're seeking B1, B2 change of status, then you have to go through I-539 application. If you're seeking F1 change of status, then you have to go through I-539 application. So most of the dependents, in order to extend their applications, extend their status, they file I-539 application rather than some other is applying for you for a visa.
Sure.
And this I-539, whoever is, except few categories, diplomatic categories and everything, everybody is required to do biometrics basically. And the problem with this is basically is that it is going to delay the process of H4 applications.
So it is going to delay.
It is going to delay for H4.
So Bhanu, I will come to that again. I think I'm getting a caller. We'll take this call, but this is a serious topic. I'll come back.
Sure.
Hello.
Hello.
Hi. May I know your name, please?
Hi, my name is Anil. Can you hear me?
Hi, Anil. How are you doing? Yes, I can hear you.
I have a question about H1.
Okay.
I am on 10th year of H1B and I have I-140 approved. Employer has applied for amendment plus extension in regular mode.
Okay.
240 days is coming in about 5 days. So what are the options to extend beyond 240 days, because the premium is not an option anymore because I have 5 days left. So what are the options to extend my work 240 days?
You still have a premium processing option available for you. You can file H1b in premium processing. I'm not sure why you don't have that option. It's a personal choice basically, but you still have a premium processing available for you, and I would say that's what you should do. The problem here is I've seen a lot of attorneys advising their clients when they file an amendment plus extension, the 240-day rule is not applicable for them because they file an amendment, and for the amendment there is no 240-day rule applicability. 240-day rule applies. For them, a strictly 240-day rule applies only for the extension, not with amendment or amendment plus extension. For me, I'm a little bit conservative in how to interpret this. I think this whole thing is caused basically because of the regulations implemented in passed in 2016 about the AC21 laws,
right?
And then it came into effect from January 17, 2017.
Okay.
There are comments by the USCIS in a preamble under what circumstances the 240-day rule is applicable, under what circumstances 240 days is not applicable. So in that, basically, the USCIS discussed about 2-3 circumstances where 240-day rule is not applicable and 240 days is applicable. But USCIS particularly specifically did not disclose if the 240-day rule is applicable if somebody files an amendment plus extension, basically.
Right.
Okay. So I will be very careful in order to advise my client it is okay to work up beyond 240 days when amendment plus extension has been filed, because amendment is filed only till the date the actual petition is valid.
Right.
Okay.
Petition is valid.
That is only you're filing amendment. Otherwise, you're filing an extension after that, basically, right? So extension always starts from the day your actual petition expires.
Right.
From that day your extension starts. So the both are governed by two different sections in the statute and in regulations, basically. Amendment is governed under the portability rules and the transfer applicability rules, basically those sections, basically, whereas the extension is governed by entirely different section, basically.
Okay.
For that, 240-day rule is applicable. So for amendments, it's not. So my problem is your amendment and plus extension means basically you're seeking an amendment, and if the case is not approved, then you're seeking an extension from the day your status expires. So your extension request comes into effect from that time. So because of that, I would be hesitant to work beyond 240 days, because once your I-94 expires, then I'll be cautious working beyond 240 days from that time. However,
and Bhanu, actually, I'm getting another call. I think a lot of people are watching and curious to know.
Sure.
So yes, we will finish off your statement. I mean, let's take this caller as well.
Sure.
Hi. Hello.
Hello.
Yeah, may I know your name, please?
Hi, my name is Srinivas.
Srinivas, can you be a little louder?
Hello, my name is Srinivas.
Hi, Srinivas. Please ask your question.
How are you?
Yeah, good sir, how are you?
I'm fine, thank you.
Yeah, so actually my case is like I applied for H1 on April 2018 and it got picked up and it is approved on January 2019.
Okay.
But in April 2019 they reopened my case again and they sent an intent to revoke notice to me.
Okay.
And they're saying that the date in the LCA is wrong and it is not matching with I-129 form, and regarding the LCA, the employer is not a H1b dependent employer. They marked as H1b dependent employer as no.
Okay.
So is that going to be any problem if they attorney reply?
It's very difficult for me to comment on this because I have to review a file, you know, and because it's a specific case scenario, and I need to know the entire facts in your case, and I have to see your notice of intent to revoke, and also your H1b filing copy. Without that, it's impossible for me to answer. And you can reach us privately. You can reach me privately to my office number. I believe it's been rolling in the credentials right over there in the show. Kindly feel free to reach me during working hours from Monday to Friday, 10 a.m. to 7 p.m. EST in our office.
Well, I will read the number for you in case you want to reach out to Bhanu. This is 70496-7722. I repeat, 703-496-7722. So you can reach out privately and take more guidance on that. Of course, every case is a little twisted and different here in this whole of the scenario that's happening for H1B. Every case is taken up differently by USCIS officials. So it's better to take a private consultation. I would recommend that. Thank you so much for your call, though.
Yeah.
Thank you.
Okay.
So, Bhanu, of course, you were finishing off with your statement regarding that 240-day
So
extension, and
I'm
of course, you were speaking about amendment and extensions being two different cases of
working beyond 240 days when you file amendment plus extension,
Right.
especially 240 days after the expiration of your I-94, not after filing an amendment plus extension.
Okay.
So there's a difference between the both. So because I approach very conservatively, especially in this restrictive time of immigration practice or immigration procedures being held by the USCIS.
Right.
And if they try to find this as a way to deny the case, because that is what is happening at the present scenarios.
I
So
understand.
they may try to find to deny the case, and again, you may end up fighting litigation. You might win the case also, but we not know. It's going to be a long process. So I'm very conservative in approaching
So
that.
basically, you will say that extension should be filed separately and amendment should
Be
be
filed separately,
as per
basically.
your opinion, basically.
I mean, it can be filed both ways also. Basically, there's nothing wrong with it. But it's
but
all.
they say usually H1b amendment is also like a new H1b.
But my issue is filing an amendment separately is always a better idea, basically because if you file an amendment and if you file an extension, there are two different petitions basically. For amendment, as long as it is pending, you're authorized to work,
Okay.
even if it goes beyond your requested start date,
Right.
because
Okay.
the case is still pending.
Okay.
You're authorized to work until the case is pending.
Okay.
So that's one thing basically.
Okay.
And if you file an extension separately, for extension there's only 240-day rule applicable.
Right.
So you can make an argument say that you're working beyond 240 days because your amendment is still pending.
Okay.
Okay, after your I-94 expired also basically. So I would always prefer advising people to do amendment plus extension separately. And also at present processing procedures by the USCIS, amendment goes to the service center where their actual jurisdiction is, that is either California Service Center or Vermont Service Center. Extensions goes only to Nebraska Service Center.
Oh, okay.
Okay.
Okay, there's a
So
difference.
the adjudication policies and the way factual reviews done by each and every service center varies.
Okay.
So Nebraska Service Center has certain particular way of factual review which they do in each
They
and
put
every
some
petition.
timelines there? Specifically?
There is no timelines. It's everyone reviews the evidence very differently. Basically,
Right.
every service center reviews the evidence very differently, and the requirements are very different. Basically, although standard is preponderance of evidence for the evidence
Right.
to present evidence, but we see the difference between various service centers, how they review the evidence, how they implement, how they adjudicate the cases, and everything. If you have a possibility of filing extension with Nebraska Service Center, I would say that you should do that rather than filing an amendment and extension basically.
Okay.
Of course, it's going to cost you more money, but
But safety is always better. You're
in the
keeping
present
yourself
scenario,
secure.
basically, that's what it is. That's my opinion. It's only
Right.
my opinion.
No, I
I'm not
understand.
saying that my opinion is correct or anything like that. I mean, still filing an amendment plus extension is a very good option if there is a possibility. Is that we do in our office every day amendment and extensions together.
Right.
So because it's all depending upon the situation. For example, if the guy's previous extension, previous status is expiring in a month, then it doesn't make any sense filing an amendment separately and filing an extension.
Absolutely.
We do it together basically.
Right.
So it all depends upon the case by case basis. So I would prefer
So
working
for
with
a
the lawyers.
person, say a scenario is there that a person has to file an amendment, he has changed his project and his extension, his visa expire, like the extension expires in say 2020 of January of 2020. And now he has to change his project in the month of October. Now he'll apply for the amendment.
Amendment.
So what is your suggestion there?
It's, as I said, it's a matter of convenience there because he has 3 months time left.
Right.
So either seeking an amendment for 3 months and then filing an extension separately,
Okay.
or filing together basically. If he has money and if he thinks it's okay to spend money, then I would say the file 3 months amendment separate and then file extension separately
All right.
with Nebraska Service Center.
All right.
Because if amendment gets denied, at least if extension gets approved, is authorized
Okay, if
to
amendment gets denied, at least you are safe because your extension is in the
approved.
process.
And
And
it's
if
approved.
extension gets denied, then your amendment is
It's
still in
process.
process, and then you can always change your
you
employer
can
or
always
whatever.
file again extension because your amendment is still pending.
Oh, okay. A next extension can be applied. You don't
Absolutely,
need to change
because your
employer.
amendment is pending, right?
Okay.
So because you're authorized to stay, you may not get I-94. That's a different thing.
that's
but
different.
at least it allows you to
Stay.
file for an extension and stay in this country.
Sure.
So this
It's
is
a
something
very
which
minute, very impactful detail. People miss out, and then definitely that's where, of course, your presence here is great today. Thank you
Yeah,
so much
thank you.
for all these inputs, and they're very important. And Bhanu, we were definitely discussing about the H4 visas, biometrics, and we were talking about that this will lead to some delays. I want to come back to H4s again. Of course, we have a list of H1s, I know, and there are callers, of course, calling for H1. So the thing is, for H4, when we speak about biometrics, first of all, this because it is I-539 liable, everybody is liable to go under.
everybody has to take biometrics.
go for the
Except few
biometrics now.
categories, as I said.
Understood. So what happens is now the situation is there are thousands of people who are also working on H4 EADs now. And they have to do their homework because you know the situation right now, the extensions are taking a long time. And if H4 EAD person, their extension doesn't come, they will not be able to work. They will have to sit at home.
Yes.
What is your guidance on that? How to safeguard themselves, avoiding those delays and everything? Okay, there is a call. I think I will take this call, and this is my question where we'll focus on.
Definitely.
Yes.
Definitely.
Hello.
Hi, I'm.
Can you repeat your name, please?
Hi, I'm Swakesh.
Hi.
How are you?
How are you, Swakesh?
I'm good. Bhanu, how are you?
I'm fine, thank you, Swakesh. Yeah, tell me, Swakesh, how can I help you?
There's a court case going on H4 EAD. Can you please throw light some on that case? Like when it's going to, decision is going to.
We do not know yet how the court will rule because it's very difficult for us to judge how the judge views the case basically. But one thing we need to understand this is that case is pending and the USCIS is not really opposing the plaintiff on that matter. So because USCIS itself is telling that they would like to cancel the H4 EAD regulations basically. However, we have to see how the court rules on this because there are quite a few amicus curiae briefs have been filed in this matter in favor of the H4 EAD regulations basically. So very difficult for me to comment on this. We have to see how the things goes on this. Sorry if I could not provide you much information on this.
Thank you so much for the question. Of course, I understand that is a concern, and thousands of people, they are waiting for the right decision to come. Their lives matter, and then of course there was some input that came out, of course, saying that financially or economically they are not impacting the American
American workers and jobs basically. And you need to understand this basically. US is in a very difficult position, right? Because there is always already a precedent set in the DACA. What happened with the DACA is the Supreme Court clearly said that they don't have to issue the DACA EADs for the new applicants, but they have to continue for the old ones or existing ones because of the severe economic impact their family will have, individual's family will have. I'm assuming if this regulation gets cancelled, I think some case laws will be filed under the similar lines or same lines, where probably court again will rule out saying that at least you should continue the people who are on H4 EAD because these people have already established businesses here, and our current president also is very in favor of encouraging small business entrepreneurs and everything. He wants to bring in people who are basically creating jobs, who are basically contributing to the economy of the country. And I know there are a lot of H4s out there who started their own businesses.
Oh, there are a lot of H4s, and even when they are financially independent, they are actually contributing by paying heavy taxes.
Yes.
In fact, billions of dollars have been poured into the economy by these H4 visa holders.
Absolutely. And I think that's where the government has a very difficult thing to do because it's going to severely impact their economy. I mean, individual families' economy basically, and how they're going to compensate that. Because what is the future of all these businesses?
Absolutely.
Okay. And especially if there are proprietorships or single shareholder businesses, what is the impact for those things basically? So these factors are very, very important, and I think our president also is in favor of any visa program that basically creates jobs, stimulates economy in this country. So
thank you so much, Bhanu. In fact, going ahead on the same topic, of course, how do you safeguard their interest now by guiding them how and when they should file for their amendments at the right time, because of these biometrics coming into the picture? Does they have to be on their EADs, and EADs only will come when the extension happens. Now the spouse is main person there, they have to apply. And then is it a great idea to apply the H4 extension along with the H1b holders, primary applicants visa application extension?
Yes.
And we put all the papers together, even for the EADs and everything. I mean, everything together.
Absolutely. You should
try and it should be filed in the premium or what?
Whichever way you're filing, whether premium or regular, try to file concurrently with H1b. Especially if you're filing premium, try to apply concurrently. Although now they're delaying. If you file premium in premium processing, they're delaying for H4s and H4 EADs basically because of the biometric process. While they're approving H1Bs, but they're not approving H4s because of the biometric process and everything.
Even though it is in premium.
Even though it's in premium, because you need to understand this basically. Premium processing is only for H1Bs, not for H4s. Right. It's always under the discretion of the USCIS officer whether to adjudicate H4 in premium processing or not. As a matter of convenience, previously when you file in premium processing H1B and H4 concurrently, USCIS to adjudicate H4s along with the H1Bs. Because of the biometrics, they're not able to do that. Even though they intend to do that, they're not able to do that right now.
So what happens? How much delay is expected when
I'm
this situation?
saying-
Say they apply in the premium, and of course the adjudication happens for the H1b primary applicants now, but the file remains stuck together, of course, and then the biometric happens. So now, what is the frequency? Like how long do they have to wait now
It's
for
taking,
these biometrics?
we are saying 2-3 months basically.
2 to 3 months for biometrics?
For everything, because biometric notice has to come to them, and the appointments are usually given 2 to 3 weeks after the notice issued to them, and they have to do the biometrics, and the biometrics has to go through, and the background checks and security checks has to be done through the biometrics,
Right.
and they have to be verified, and then they're going to adjudicate the case.
Well, this will be a great block for them, because like it will be a bad blocking, What happen is, in that scenario, I believe the H1b, the primary applicant will have to apply the extension almost 4 or 5 months before.
Basically, you have an option to apply 180 days before your prior
So 180 days is 6 months again, and then they can apply in premium even then, right?
Yes. Yes, they can.
Okay, so
And
I have another
I would
caller
always
here.
advise H4s and H4 EADs to file at least 180 days before,
Right.
and file H4 and H4 EAD together.
Okay, you say 180 days before, not 180 days before.
At least 180
At
days.
least 180. When you reach out to that 180th day or 179th day, you should apply for your extension. The primary applicant should apply for his H1 extension, and concurrently the H4 person should
H4 and
apply
H4
their
EAD. I think that's a very good idea to do that.
Yeah, I mean, understanding the current scenario on rejections, denials,
think-
wait time and everything.
Exactly. In the reason why I would say at least 180 days before is because, let's assume that because of the extensions denials happening quite frequently these days, even if its H1B the extension gets denied, he will have an opportunity to refile it again.
Yeah, I understand
Because he
that.
still have valid
He still has a
I-94.
valid H.
So he knows exactly what is the reason why it has been denied,
Right.
what is the USCIS looking into, and he tried to gather the evidence based upon that and provide that evidence. And most of the denials are happening because of 2 reasons, right? One is
We will
special-
come to those 2 reasons, Bhanu. Again, there is a caller, and I believe we'll take the call. Hello, can I know your name, please?
Yes, sir. Yes, madam. My name is Rajeshwar.
Hi, Rajeshwar.
Yeah.
How are you?
I'm good, madam. My question is, like, my wife is on H4 EAD,
Okay.
and her extension is applied recently. Can she work on the still work on with extension, or she need to wait till get the approval or decision on that?
If her EAD is expired, then she cannot work until the H4 EAD is approved, or extension is
Okay.
approved. If it is still valid, yes, she can continue working.
Oh, okay. Thank you, sir.
Sure, Rajeshwar.
Thank you so much. Okay, so there's the series of questions in sync right now
Yeah.
with H4s. Okay, so before 180 days, under 180 days you have to apply, not before exactly. So 180th day you start applying, and you, irrespective, you apply in regular or premium. But of course, premium is better because you will get your decision fastest, and if you have any rejection coming in, at least your I-94 is valid, so you can again apply for another extension.
Yeah, it is something which they have to consult with their attorneys. What is best for them, whether it's applying in premium processing, regular processing, based upon their situation.
But
What
again,
kind
we
of
have to
evidence?
buy time for sure, for H4s at least.
Yes, H4s obviously. That's
I mean,
the reason
buying
why.
time is apply way
That's the
before.
reason why it's better to file in advance, because H4s can't work if their EADs gets
That's a
expired.
very, very miserable situation, honestly. This is very tough because, first of all, again, there is still a tough situation for the H4 EADs to get the jobs in the market. And once they are placed at good, respectable positions, it is really tough. If this scenario comes into picture, they'll be just losing their whole of the self-confidence, esteem, and independence.
My
economic
experience tells me
independence.
that very few work on H4 EAD. Most of the H4 EADs do their own business.
No, they do their
And-
business, they're working as well.
Yeah,
I would
but
say that, but everybody's interest has to be safeguarded, and of course, right kind of guidance at the right point is very, very important right now. I mean, I'm
Yeah, yeah.
bringing you in here and having this discussion itself is an eye-opener, because right now what's happening is there are people who are just, waiting for their time, and okay, extension will come, then we'll think about all this. So sometimes we stay in our own beautiful world, thing is all said, you're working, wife is working, extension will happen. So once that happens, okay, we will go for biometrics, and it will happen in 2 weeks because it's premium.
Yeah.
But you are showing that you are throwing that light, which is very important at this point of time, understanding. Even though you apply in premium along with your spouse, the primary applicant, you will not get your H4 EAD extension because biometrics has come into the picture.
I mean, there's a possibility sometimes you get approvals. It's not that you don't get
But the
approvals.
biometrics, they have to go still.
See, what I'm saying is sometimes it can happen within those 14 days also. It all
Biometrics
depends
also?
upon it all depends upon the officer, right?
Right.
So it all depends upon the officer. So I'm not saying that you don't. Basically, there could be some cases where they can.
Right.
But what we are seeing is a general trend general trend is that, yes, they are basically getting delayed because they have to go through the biometric process.
Absolutely. Thank you so much, Bhanu. This is a great input, and it is kind of a warning input. I call it as a warning. Take this warning very seriously. Do your homework right at the right point of time, and that's where it is. Now on H1B, let's come and again discuss. Of course, a lot of questions came in, and of course we have met halfway. H1B extensions. First of all, your inputs I would take from you now. What is happening currently with USCIS? There were litigations happening on lot of denials that happens, and then there was a contest saying, why are you denying petitions out of nothing? There is no big reason, and extensions have been rejected, amendments have been rejected. Throw some light first on what is happening currently.
Okay, the problem is USCIS basically, we have seen the increase in denials from 2017 onwards, right? Basically, and we strongly believe there's a substantial change in adjudication policy by the USCIS in adjudicating H1Bs, right? And they're basically imposing higher standards of burden of proof than what is required by the statute. That's what at least we feel like lawyers.
Well, there are many conditions imposed which were never even thought about earlier.
I mean, very difficult for me to talk either way. Basically, as a lawyer, as an attorney, I cannot be biased. Basically, I have to be neutral. Basically, and USCIS is basically looking into certain aspects, basically, which probably do not know whether that warrants from the statute or not. As an attorney, I strongly doubt whether those things warrant from the statute or not. So that is an issue which is going on, and basically because of that there are a lot of denials happening, especially with California Service Center, on especially regards to the specialty occupation and right to control, employer-employee relationship. And see, there are a lot of cases have been filed in the courts, and recently I was privy to one of the hearings in one of the most important litigation happening right now. I think that case will tell us a lot. What will happen, what will be the outcome of that case will tell us a lot, basically how the program will impact in the future, basically. If the case comes in favor of the plaintiffs, then it's good for the industry, good for especially for the IT consulting and healthcare consulting industry. And things will become better because we have seen tremendous changes in the education policies, right? After February 22nd, 2018 memo, we're clearly seeing that they're approving H1Bs for 1 day sometimes, even for 2 days sometimes.
In fact, we have to talk on that, of course, that's where it is.
And those memos and those approvals are coming way after expiration of their status also, basically, right?
While into the continuation of the talks, we were discussing about H1B extensions, and there was a topic, of course, Bhanu was telling about that, where people were getting extension for a day also, in the rarest of the rare cases, and of course for a few months also. So Bhanu, throw more light on that and the miseries which are faced by the people on this, on the H1 visa when this kind of situation happens, because they immediately become out of status.
This is the consequence. I do not know whether the USCIS forethought about that or not when they issued the February 22nd, 2018 memo, you know, where they said that USCIS has a discretion to approve the H1B petition till the duration they deem it's appropriate. What does it mean is basically is that if the employer could not provide a proof that he has a job for 3 years, if he provides a proof only for 1 year, 1.5 years, like for example in the form of an purchase order or an agreement or anything like that, so they're going to approve only till that time, basically, and that is the discretion which they have given to the USCIS officer. That this is a substantial law change, but it's been implemented through a policy, basically, by the USCIS. And this policy is created a huge problem because in practicality, sometimes they're approving, because of the huge delay in adjudications, basically, of the H1B petitions, and when they're adjudicating, they're approving it for 1 day.
Because the time has already lapsed.
Already lapsed, by the time the adjudication happened. And either USCIS has to improve their adjudication faster, or they have to figure out whether it's legal or illegal to do that. Therefore, there were case has been filed on this, and the judge was very strongly contesting with the DHS on these issues, basically, and about this one, about the employer-employee relationship, about the non-speculative employment, and all these things, about the case which I talked to you right before. So, hope the case comes in favor of the plaintiffs, basically, because that will really sort out all these issues with the USCIS.
Right.
If the case does not come in the favor of the plaintiffs, we have to see how US is going to act on those issues, basically.
Do you
But
see any class action lawsuit?
that is what actually happening right now. That was a class action lawsuit which has been filed,
Right.
which has been heard by the judge recently in
Okay.
DC, in Washington DC, and I'm a little bit cautiously optimistic and hopeful that judgment will be in favor of the plaintiffs, because now still they have the plaintiffs and the defendants have a time to submit their briefs again,
Right.
and after the judge will decide whether to do any discovery in this matter or not, and if there's no discovery is required, then they may go ahead and judge may go ahead and give a decision, basically. But we have to see how the judgment goes. But plaintiffs have made a very valid points in this case, especially with the lengthy adjudication delays in the H1b adjudications, basically,
Right.
and also about the providing definite itinerary for the employment for the entire duration of 3 years, and the speculative and non-speculative employment. And those issues are really core. They are basically core subject and core subject matter issues for the H1b adjudications, basically.
Right.
And they were basically talking about those things, basically, this case. I'm eagerly looking forward for the outcome of this case. Hope it will be good. If the case comes in favor of the plaintiffs, it will be very good for the IT consulting industry, healthcare industry, and everything.
Right.
We don't see this kind of erratic decisions. I would not say erratic, basically. What I would say is the decisions are very inconsistent. We do not
Right.
know exactly what USCIS is looking into in approval of the H1b petition, basically. That causes very difficult for the lawyers as well as the petitioners who are seeking benefits, basically, in the country.
Right.
Let's hope this will sort out and provides us proper guidance exactly how it is going to go. So we're hoping how the judgment will be from the judge.
Well, our hopes are high only, of course, for the entire H1b community, and a lot of stake is there, like people's future, their finances, their families, their kids' education, their future. Everything is at stake when we speak about, especially with the extensions of these H1s.
yeah,
everything is. I mean, they're here in this country for. I mean, there are people who are in this country for last 15 to 20 years.
Yes.
And of course, they are waiting for their green cards, and then it's a never-ending process of applying for extensions again and again and again. Sometimes, as you said, sometimes they'll get an extension for a year, for a month, for 3 years. This is also kind of has a, whether your lottery is open. I mean, you get a lottery for 3 years extension, or you get a lottery for 1 year. I mean, not technically, but yes, this is what it is.
I mean, there's a lot of inconsistency in security because of this in H1b community. I believe the government should find a solution on this, because these people are contributing a lot to the economy one way or other.
Absolutely.
And they're professionals, basically. They're not some coming in a low-end jobs and trying to take over the jobs from the US workers, basically. I mean, I cannot comment on that, but that's entirely different topic. But I think let's hope what the judge will say on this matter.
For the H1b community per se, if you were to give them a little guidance about when they actually ensure their filing of papers is good in terms of their amendments and extensions, what are the primary things a person should keep in mind while filing their amendments and extensions?
It's depending upon nature of the job they are in, basically,
Okay.
right? I mean, there are H1Bs are used by various industries, basically, in a vast industry and everything.
Right.
So it's very difficult generically to say that this is okay, but depending upon the industry, we can tell what is required, what is not required to seek an approval, basically, right? We will talk an example, because especially Indian community,
Right.
Most of the H1Bs are used for the IT consulting and healthcare consulting
Right.
companies and industries, basically. For those positions, basically, what I mean by IT consulting and healthcare consulting is that basically third-party service companies, I mean third-party employer petition, basically.
Right.
That means the employee does not work at the location of the actual employer, but at the third-party client side. And for that, some employer petition saying that they have a requirement for this employee to work at the X client
Right.
for X number of time in X position, and these are the requirements for that position.
Right.
That is the basically consulting model. It's called, there are the different types of names they're called EC model or EVC model or EVVC model or EVVVC model. That means basically employer vendor client or employer client or employer vendor client. It all depends upon those models, and these models are very well accepted by the USCIS, saying that they're legitimate business models basically,
Right.
and there is no illegality or there is no illegitimacy in that particular business model.
Right.
So, under those circumstances, actually we are seeing more denials, right? I mean, that's where we are seeing more denials, is
Right.
basically because these employers are not able to prove proper employer-employer relationship as per the USCIS requirements, how they are basically actual employer.
Right.
They are not some employer who are trying to file a petition, but they're actual employer basically.
Right.
The standards for them is to show that these employers actually control the work of the beneficiary basically, right? So the employers should secure documents that clearly shows or demonstrate that they actually control the work of the beneficiary when they work at the third-party client side.
Right.
You know, and that is where the whole thing comes. That evidence can be shown either in the form of the letters from the client and also the purchase orders, agreements issued by the end client to the employer directly or to the vendor if there is any vendor in between. So that's how it can be established. These documents needs to be properly reviewed and should take opinion of the lawyers and see whether those documents are meeting the requirements with the USCIS or not.
Right.
And certain things are minimum requirements that's supposed to state these documents basically, right? What is the position they're hiring for? What are the requirements for this position is basically. Whether this position qualifies as a specialty occupation or not is determined based upon that.
Right.
Okay, and at the same time, whether the beneficiary qualifies for that or not, whether he has a required education in the specific specialty for which is being employed or not. So these are the criteria, these are the things which every employer and every employee has to work through and go through that and everything.
And in fact, thank you so much for these inputs. In fact, lately what I have actually, I read somewhere was the USCIS officials are visiting the client sites to
visits.
verify whether the worker is actually working there or not. So what happens in the situation if somebody is working from home sometime because of some sickness or something, and the the authorities visit the office?
If it's only occasional working from home, like for example, if it's because of the, I would say occasional or temporary working from home, like because he's sick or anything like that, it is okay. What happens is basically is that if the officer visits at the site visit and if they cannot meet the employee or anybody else about the particular position, what they usually do is basically they send an email to the employer and employee and ask for the verification of the information and everything. And once you provide that information, basically, again, officer, depending upon his own choice, sometimes they may revisit to the location where the employee is and try to meet with him and get the information.
So, okay, basically they do not take any single decision on the day itself.
No,
I mean, they will still wait for the response.
I've not seen.
Because there are some chances, you know, where somebody has a kid's school visit or something.
FDNS officers have no authority to adjudicate petitions.
Okay. I mean, putting any comment, even positive or
They
negative.
only have to provide the report to the USCIS.
So they'll say the person is not available.
Exactly. They finish the report and they give a report. They're just like analysts. They cannot give an opinion or a decision. They can only write a report of the facts of what they viewed or what they inquired. And they have to put that in the report, and that report will be given to the DHS officer, that is USCIS officer.
Perfect.
Or whoever it is basically. And the DHS officer will determine whether to adjudicate the case or whether to refer to the ICE for further investigation or whatever it is basically.
Okay, so it doesn't even finish there, they will further investigate.
Exactly.
Great. Thank you so much. It was a very important report. I'm having a caller right now. So, hi. Hello.
Hello.
Hi, may I know your name, please?
Hi, Jyotsna. My name is Satish Pandey. I'm calling from Seattle.
Hi, Satish. How are you?
I'm doing good.
I hope
How
you
are you
are enjoying this whole, knowledge-based session right now.
Yes, I'm doing. So thanks for sharing the information on high-skilled immigrants grow.
Thank you so much.
I'm also part of that, and I came to know about this webinar.
Okay, Satish, ask your question.
Okay, so hi, Mr. Bhanu. My question is regarding. So there are two questions. One is regarding the recent announcement related to legal immigrants. So, do you see any possibility for the backlogs community in terms of like clearing backlog, or when President announced about the merit-based system? Do you think they're going to consider anything as part of this process?
Hi, how are you?
I'm doing good.
It's a very good question. Honestly, answer is I do not know. The reason why I would say I do not know is basically because the president has proposed the merit-based immigration, but he did not tell exactly how he's going to implement it. Basically, what are the requirements he's going to look into, what he's going to do with the current people who are actually waiting in the line with this merit-based immigration system. Are they going to be given any priority or not priority? We do not know that. Only clue or any idea we have is basically the bill. There was previously an immigration statute. There was a bill was introduced in the Congress about the merit-based immigration, which was not gone through. That bill gives you a rough idea where the president is actually looking into. As per that bill, it doesn't give any relief for the people who are actually waiting in the line. They have to apply through the merit-based, point-based system again, and also on every year basis, which based upon that bill. We do not know any guidelines, anything yet from the president, but the announcement by the president is somewhat looks very positive, and seems to be is very serious about doing something with the immigration reform. We have to see whether he'll gain the momentum and whether he gains support from both the houses in the Congress or not. But let's hope that from the House and from the Senate of the Congress. But let's see how it goes basically. As far as we know that there are certain bills are pending for the removing the per country limitation for the backlog for the individuals and everything. I do not know that how positively that will take effect and will come through without any compromises in the Congress and in the Senate also. So it's a lot of issues are pending with the USCI, with the Congress, and with the president about the immigration reform. We have to see how it's going to be. We will hear quite a few news coming in few coming days and everything basically.
Thank you for the input. I believe you have another question as well, right?
Yeah. So you partially answered my question on HR 1044. I was about to ask because we already have 290 co-sponsors, and as per the most recent update from Congress that whenever any bill has 290 co-sponsors, it will automatically come on the floor for discussion.
But it has to go through the process. Even if it has to come to the floor, it has to go through the process. And if let's assume that if it passes in the House as it is, the same bill has to be adopted, its version in the Senate, and the Senate also has to pass through it, and then it has to go to the president, and the president has to sign that bill. There is no guarantees here, and keep doing the great work in lobbying and everything. Let's hope that something will formulate on this. See, I personally also worked on this quite a lot. I've done quite a few. I participate in rallies with various organizations for hopefully to get some kind of relief for the immigrants in this country, especially with the per capita for per country limitation issues and everything. But we have to see. I'm very realist in expectations. Basically, I would tell people to expect what the reality is and see basically what can be done, what cannot be done, and try to find a solution by promoting or promulgating or fighting for common sense regulations basically. The Congress is not going to vote for you just because you have putting force and everything. They're going to see how many votes are coming, who are the voters basically, whether there's going to be a vote bank from particular community or not to pass a bill or anything like that. Make sure that in whichever community you guys are in, make sure that you participate in the local community. Make sure that you basically make them aware, the congressmen in that community, basically what to do, what not to do. Make sure that you have a valuable vote for him to win the election in his community basically. As long as the congressman understands that you are a valuable vote bank to them, they're not going to take any action on this. And when I talk about this issue, even in public and private, I'm very strong, very realistic, basically how the community should approach on these issues. And they have to be very careful on what they navigate, what they have to navigate. Otherwise, they will lose everything despite putting all these things. We have to be strategically approach these issues basically. So make sure that you participate in the community. Make sure that your congressmen are educated on this. See, many of the congressmen does not know what is legal immigration is. If they think immigration, they think about somebody is crossing borders in Arizona or in Texas. That's the reality. So we have to make them understand what is legal immigration is, what is H1b program is, what is per country limitation is basically, how legal immigrants in this country are suffering by not getting the green cards for years and years and pending in this country, how much hindrance it's causing for them. It's important for us to work on that and go through that. There's nothing wrong in participating in local town hall meetings. There's nothing wrong in going to the congressmen, senators in the local communities and talking to them. And that's what I would say. Don't go and try to say that, oh, this is what we are staying here for 20 years, we want solution on this. It's not going to happen. We have seen this from 2008 onwards when people rallied for legal immigration in this country. Congress is not going to come together and do this unless they know that you are a secure vote bank and it's going to be beneficial for them in the coming elections and whatever it is basically. So put on that, basically put on work on that. That's very, very important. Try to figure out a way, find a strategy. What is most sensible thing is, if the immediate solution for you all is basically is getting a EAD card, if that relieves you from going on this extensions and worries of denials of H1Bs and L1s, I think guys should find a solution how to get EADs basically, rather than fighting on getting a per country limitation and everything, because that's a very good one to fight on. At the same time, along with that, try to fight on getting an EADs and everything also, so that you find a solution on this. So it's very, very important. I'm also an immigrant like you all, right? I was fortunate. I mean, I've been here for 15 years ago. So before this backlog started, I was fortunate to get my green card. It doesn't mean that everybody is in the same boat. Even I know a few of my friends who came along with me in the US are still pending. They don't have a green card. They're still in the backlog. They're in the line. So what I'm trying to say is basically is that, and I hear this pain every day in my office. I see this pain every day in my life. And my humble advice is work for common sense legislations basically, and try to work on that, and try to work with the congressmen, try to work with the senators, and try to get some kind of a medium or some kind of a balanced legislation, so that the bill can be passed and the president can sign it. That is very, very important, because president has to sign it even if the Congress passes it. Okay, and that means president's base should approve it. He's not going to do anything unless his base is going to approve it. So we have to understand that basically. So please work on that.
Thank you so much. Thank you so much for your question, and thank you so much, Bhanu. In fact, I'll thank you from different orientations now. Okay. I saw your passion coming out. I mean, I saw a human being speaking here, not an attorney exactly. The way, passionately, the way you explained everything speaks it all about your, inclination towards the legal immigrants in the country, inclination towards the H1b community, F1 community, H4 community in this country. And I take pride in mentioning this, that yes, you are guiding a multitude of people other than your official life, office professional life about this, and where you are working for the cause hands in hands together with the legal immigrant community. I know you, I know Bhanu Illandra, and he has definitely participated in a couple of the legal immigration rallies where he also joined hands together to speak about removing this green card backlog. He supports the Indian community. He is one brother amongst us, and that's where he deeply and passionately spoke all about non-stop, and I did not disturb him while he was passionately guiding us. See, the thing is, when it comes to the advocacy, when it comes to seek your rights, when it comes to your green cards in this country, as Bhanu said, and as everybody says, it is more about educating. In fact, it is more about bringing facts to the light in front of your congressmen and senators, in front of your policy makers. So, if you really want to achieve success, yes, it becomes mandatory for everybody who is there in this green card backlog to call their congressmen, their senators, meet them in person, show them some examples, some live examples, show them the stories of their legal dreamer kids who are actually facing a lot of misery and not able to make their career in this country. But it all happens when you are able to connect with the right people in the law, in the circles of the law. In sense, you have to reach out to the senators, congressmen, policy makers, your councilmen, your mayor, and everybody. The people who vote, the people who will vote for this government are the people who are US citizens. You need to make friends with them. You need to educate them. The whole change will happen when the voter will decide to bring the right person who takes the right decisions. President Trump has definitely given a statement, a proposal to do something good for the legal immigrant community. But it all will happen once whole of his proposal goes into the House and the Senate for the votes. And these will only happen, these votes will become successful only when the concerned senators and the congressmen are, aware about this situation. And this can only happen when you people go all out and meet them. If you're sitting at home, watching TV, watching news, reading some articles and blogs on the internet, and you think the magic will happen, it's not happening. I'm so sorry. I also am a staunch supporter of people, who are stuck in the green card backlog, and I support them to get the right justice. That's the whole story when this whole series began, Voice of Legal Immigrants, because I care for you, for the people who are absolutely in an unjust state when they're waiting for 15 to 20 years in this country for their green card, while they make America much more stronger by their innovation, by their experience, by their abilities, where they make this country stronger in terms of economy, in terms of socio-economic perspectives, in terms of education, in terms of technology. We Indians take pride there, and I definitely appreciate Bhanu on his take, and yes, we learn from each other. What he said has a deep meaning. So we really cannot stay still into a rosy world expecting the miracle to happen unless we get up and do our task.
Exactly.
Well, it was a long lecture from my side as well.
No, it's a good thing. It's a good thing because it's very important, because people need to understand when we express ourselves, basically certain points, we tell them on the both side of the points of view. So sometimes it can be misconceived by the people. Right. Sometimes it can be misunderstood by the people. People think that, oh, why is he talking on the other side?
No, it's a neutral view. I'm
just telling you basically. So it's very important for them to understand this. See, the per country limitation is a great thing, but problem with that is basically is one way I see the problem with that is diversity issue. Okay?
Bhanu, actually, this will be a long discuss for debate.
Yeah.
Let's not take it right now.
Yeah.
Actually, I have a caller here, so we will take the call. Hi. Hello.
Hi.
Hi, may I know your name, please?
Yeah, this is Ashwin.
Hi, Ashwin. How are you?
I'm fine. How are you?
Good, thank you. Tell me, ask the question.
I have two questions regarding the legal immigrants. The first one is there any limitation, suppose work location is changed in a metro area? So, do we need to submit a H1b amendment for that one, or LCA, new LCA, within 20 miles radiation in the metro area?
I'm sorry, Ashwin, how are you?
Yeah, I'm fine. Bhanu, how are you?
I'm fine, Ashwin. Ashwin, the question here is basically you are asking about whether it is required to file an amendment if you're basically changed your location within the commutable area, right? Within the same metropolitan statistical area.
Yeah.
The answer is no, as long as the position is same or similar position. As per the matter of Semio solutions and the subsequent USCIS memo, they clearly provide a guideline saying that if somebody changes the location within the same metropolitan statistical area, that means which is within the normal commuting distance, they do not have to file an amendment basically. That means they don't have to take a new LCA or file an amendment. Only requirement is that they have to do the LCA posting, existing LCA posting at the new location for 10 days on or prior to the joining at the new location.
Okay. So, is there any issue with the port of entry while coming back?
No.
Changes in a.
You should not.
So we need to say the new. Okay.
You should provide the new client details where you are going to work. Should not be any issue.
Okay.
Yeah.
Okay. So second question.
Okay. Second question is that
for the child, how many years they can be as a dependent in this country? Means is it at 18 years or 21 years?
Up to 21.
Oh, the kids.
Up to 21.
You're talking about the kids, right?
Yes.
Kids up to 21.
Yeah, for the kids.
Up to 21.
Up to 21. Okay. And the last question I have, the H1b petition can work for completely for the work from home? Is there any option? Because you brought the one of the point, so that's what I was asking.
H1Bs can work from home provided the petition has been filed for that particular location. That means in the petition, if the H1B employer explains to the USCIS that employee will be providing services from home and it is the benefit of the H1B worker and it does not, and he will be provided same working conditions as to the US workers even though he works from the home, then there is no problem at all. He should be able to work from home.
Thank you so much, Bhanu. It has been an excellent session altogether. while we covered about the facts about F1s, about H4, about the H1b. Our callers were extremely wonderful today with the right kind of questions that were thrown in, and they made my work easy because my list got reduced because the questions were already on the plate.
Yes, yes.
So, Bhanu, thank you so much. Any final words you want to give to your viewers today before we close the show? It was excellent. In fact, amazing information from you. We thank you so much. You have come all the way from Virginia to New Jersey studios today, taking all those pains, and it really takes a big heart to come all the way, and help out the community in general.
Sure. Thanks, Jyotsna. Thanks, Jyotsna, for giving me an opportunity to participate in your show. And this show is excellent, and I'm really thankful for giving this opportunity.
Thank you.
And we had a very good discussions in this, and my humble request is basically, at the end is that keep doing what you're doing if it comes to the legal immigration benefits, like especially with the per country limitation and other things. Work for sensible laws. Make sure that you advocate and you basically bring awareness to your congressmen and your senators in the local area. They should not think that immigration means just somebody crossing on the border illegally. That is very, very important thing. And as long as you guys do that, I think we'll head in a very positive state. And do not lose hopes. Still, American dream is possible and achievable. My humble way advice is don't lose hopes. Be positive and be realistic. Be realist at the same time. Be positive, and that's my whole thing is. As long as you're well qualified, as long as you're doing things right way, I don't see any reason why you have to worry about your immigration situation or status in the United States. I wish you all the best, and thank you very much for listening to me, and thank you very much, Jyotsna and Mana TV, for giving me this opportunity.
Thank you so much, Bhanu. It was excellent, amazing day, great information for my audience and my dear friends. The buck stops here. The buck stops at your decision-making skills. The buck stops at your willingness to do the right things. A very positive news has come from the President of the USA supporting the legal immigrants here, and your dreams can come true, but it is just the beginning. The steps that you have to take were already mentioned here when we speak about connecting with your congressmen, with your lawmakers, with your senators. If you do that, your life will be easier, and I hope these multiple extensions saga, for the H1b holders or H4s or whatever, whosoever you are, these extensions will reduce once you get your green cards, and this can only happen when you get out of your homes and do the work what is required.
Yes.
Well, Voice of Legal Immigrants will always bring to you the right kind of information, the right kind of guidance, and the right kind of people who are passionate about helping the legal immigrant community in the United States of America. So we say bye-bye to you now, but then keep watching us with more informative sessions from now on. Thank you so much. Stay blessed. God bless you. God bless America.